A very glad evening, friends. This is Madhavi on behalf of KingMakers IAS Academy with you for the 5 editorials of the week. Today, we are with the 118th edition. We'll be discussing the 5 most important editorial that will be very useful for your prelims, mains, as well as your interview, that is personality test. The firstly, we'll be discussing about the data protection bill, which is very useful for your GS2. And the secondly, we'll be discussing about the sub-categorization of OBC under Rohini panel. And then we will be discussing bureaucracy, how it is acting as a prosecutor as well as a judge. And fourthly, we'll be discussing about the CHIPS Act of the US, about the semiconductor development and how we can learn from that. And fifthly, we'll be talking about the Project Tiger and the recent report which says there is increase in the population of the tiger and what are the way forward. So here we go with this first important editorial. For that, again the topics here. Now, what is data protection bill? So, you know, friends, this is very important for your GS2. So GS2, we have this data protection bill, which is very important for your, uh, where you will learn about many of the acts and bills. So acts and bills is very important. There can be a critical analysis that can be asked in your GS. So this here we go with this data protection bill. In this data protection bill, as you know, we will be discussing about the critical analysis of it. So friends, you know, already we have discussed that data protection bill, that is shortly called as DPDP. It is very important that is there are data controller, or they are called as data fiduciary, and there is something called as data principals, who are the people who are giving the data. So data principal na namada, who are giving the data, and there are data fiduciaries who are responsible for saving our data and using our data. So these are the people who are using the data. So these data fiduciaries, so fiduciary means who is responsible for carrying and protecting our data. So they can be a private company, or they can be a PSUs, or they can be a government itself. Even NGOs, civil societies, all comes under as a data fiduciary who is taking our data. So here it is the people or the individual or even the private company also can be a data principal when it comes to government. So government, when they are registering with the companies and all, are having a hold of the data. So the government will act as a data fiduciary when it comes to private companies as well as people. And sometimes the private companies can take our data, say for example, for processing our SIM cards, for registering our SIM cards. Airtel or Vodafone can be our data fiduciaries. So these are the thing. So there is a important thing that we all know, Puttaswamy case. So Puttaswamy case கடத்து வந்து நம்மளுக்கு வந்து எல்லாருக்கும் தெரியும், the data privacy or the right to privacy is very important for our fundamental rights, which is coming under Article 21. So it is an implicit right under Article 21. So right to privacy is under Article 21, which is an implicit right. This Article 21 is about life and personal liberty. So to enjoy a good life, to enjoy the personal liberty, it is important that we protect our data. So for that, privacy is very, very ultimate thing. It was realized in the Puttaswamy case, and so we are enjoying now the privacy. But it's without protecting the data, it is no it is fruitless if we enjoy the freedom as only. So whenever there is a freedom, there should be some legislation which protect that freedom also. So we need a legislation to protect our data, which is a private data. So our personal data, say our biometric data, our demographic data, our educational data, everything is coming under personal data. What is my non-personal data? Any data, like the places I go, the the places I go, or the movies I like. These are some of the non-personal data. It can be very general also. It can be very specific also. So these are non-personal data. There are personal data like your name, your biometrics, your sex, your date of birth. These are all the personal data that is very important for you. Even your medical history or your anything a medical history or ailments. So that is very important, as it is considered as a personal data. So we are providing, so say for example, there is a health insurance company. There is a health insurance company wherein you are giving your personal medical data. So this health insurance company becomes a data fiduciary, and while you are as a patient becomes a data principals. So it is this insurance company who has to hold your data. They have to protect your privacy. They should not use the data for any other purpose other than the health insurance that they are providing. So they should not use the data for any other thing other than the health insurance they're providing. But sometimes it happens that this health insurance company may use your data, or it can give the data to the third party. The third party can be, say, they can be a some a lab, or some medicine pharmacy. Using the data, the pharmacy or a lab may be giving you some hint about, or some ad about giving some lab test. Or say for example, you have a bald head. உங்களுக்கு வந்து சொட்டத்தலை இருந்ததுன்னா, if you have a bald head, okay, they can send, there can be some advertisement about hair transplant. So all these are using your data that you have given to the health insurance company, that have been shared with the third party. The third party is using it without your knowledge. That is the problem. Without your knowledge, they are making money, they are commercially using your data, and they are doing some advertisement or something else also. So this is the problem. So the data fiduciary who's holding your data should protect it first, then they should remove it when you want it to be removed. They have to use it on only on your consent, and they can send it to a third party only after your consent. And also, it is important that they have to protect it from any breaches that can happen, like in the aims and all the aims, there was a cyber attacks, so all the personal patient data gone. So this is a breach, so there should be a proper protection against these cyber attacks. So the data fiduciary is wholly responsible for this, and they should not let the data for any illegal purposes also, for illegal as well as unapproved purposes. So even if the purpose is for not, if you have not given a consent, so உங்களுக்கு தெரியாம பண்ற விஷயங்களும் இல்லீகலாவும் பண்ணக்கூடாது, உங்களுக்கு தெரியாமையும் பண்ணக்கூடாது. உங்ககிட்ட கன்சர்ட் வாங்கி தான் அவங்க பண்ணணும். அண்ட் ஆல்சோ அவங்க வந்து அவங்களோட வல்னரபிலிட்டினால, இல்லைன்னா அவங்களோட கேர்லெஸ்னஸ்னால, இல்லைன்னா அவங்க ப்ராப்பரா ப்ரொடெக்ட் பண்ணாததுனால உங்களோட டேட்டாஸ் வந்து சைபர் அட்டாக் கிட்ட போயிடக்கூடாது, சைபர் த்ரெட் ஆர் சைபர் கிரிமினல்ஸ் கிட்ட போயிடக்கூடாது. ஸோ தீஸ் ஆர் த இம்பார்ட்டன்ட் திங்ஸ் தட் திஸ் பில் வில் ஹாவ் டு லுக் அட். பட் இஸ் இட் லுக்கிங் அட், is it enough protecting? So that we have to do it in the analysis. So we have already discussed in some important analysis about this data protection bill. So let me recall that. So in analysis, we have already said it is only protecting your personal data and not your non-personal data. But there is a problem that using your non-personal data, some may profile you. Some may use that non-personal data itself to profile you. Say for the movies that you like, or the places that you have gone, using your location. All this can be used to profile you or reconfigure your personal data using that. Say, what is your location? What is your home location? What is your work location? They can use it to reconfigure. So not protecting non-personal data is leaving many room for many cyber attacks or many antisocial elements to use your non-personal data for personal purposes. Another thing is the data protection board that is not having any suo moto power. So these are the two things that we discussed, and also we saw how it is affecting the RTA Act. There was an RTA Act which says that any information, even though it is personal, can be published if it is for larger public interest. But this particular bill, DPDP bill, is it is taking away this. So using a DPDP bill, it is diluting the RTA, saying that personal data cannot be revealed even if it is under RTI bill. So this is another breach or this is one concern about this DPDP bill, which we have already discussed. So now we will do the other important lacunas and other important good moves in this data protection bill. So நல்ல விஷயம் கெட்ட விஷயம் ரெண்டு விஷயமும் பார்த்துடுவோம் இப்போ. So now going with this, already you know the history of this data protection bill. நிறைய attempts வந்து இதை ட்ரை பண்ணி பார்த்துட்டு அப்புறம் தான் இப்போ ரெண்டாவது டைம் வந்து இதை ஃபர்ஸ்ட் வித்ட்ரா பண்ணிட்டு அதுக்கப்புறம் திருப்பி வந்து they have given the draft bill and now it is now in the parliament. So 2017 there was a committee, you all know, it is Sri Krishna committee that started with this data protection bill. So on the committee they gave recommendation and then it was tabled as a bill, but the bill had a lot of problems, so it had to be withdrawn and later it has submit another bill. Now we have the new bill, which is not enough published. This is one criticism in the starting itself. They have not enough consulted with the public. This is the one important thing. And also there was not proper release of information using the right to information. So the draft bill, the new draft bill has not been properly consulted is the one important concerns that have been raised in the starting itself. So this is very important for you to understand, friends. This has not been consulted enough. 1 year on the parliament without clarifying how on what basis these changes were incorporated. So friends, the first bill was introduced, then there was a public consultation, there was a lot of changes that was forwarded, but how much this 2022 bill is implementing the changes has not been published. So this is another concern that the author is saying. So this is very important for you to understand. Then what has the bill saying? So bill வந்து data principles என்ன பண்ணணும், data fiduciary என்ன பண்ணணும், data protection board என்ன பண்ணணும் அப்படின்னு ஒன்னொன்னா சொல்லியிருக்காங்க. அதுல என்னென்ன lacunas, என்னென்ன challenges இருக்குன்னு நம்ம பார்ப்போம். So role of data principles, the right to request from the data fiduciary a summary of the data, personal data being processed is okay. So we have a right to request. So the DP, that is the data principal, has a right to request from the data fiduciary a summary of the data, personal data being processed. So every time the data principal can call for any information from the data fiduciary about how they are using their personal data. So எப்படி எங்களோட personal data யூஸ் பண்றீங்க அப்படின்னு சொல்லிட்டு data fiduciary கிட்ட data principal வந்து கேட்கறதுக்கு எல்லா ரைட்ஸ் இருக்கு. So this role of data principals clearly says what is the rights of the data principals, what is the duty, uh, what is the roles that they have to play in data protection. So all these are mentioned in the role of data principals, and also they can ask for correction, completion, update and erasure from the data fiduciary also. And there is also a that earlier, அதாவது இதுக்கு முன்னாடி வந்த பில்லுல நம்ம வந்து டேட்டா ஃபிடியூஷரி வந்து டேட்டா பிரின்சிபல் வந்து என்னோட டேட்டா வந்து ரிமூவ் பண்ணுங்க அப்படின்னு கேட்டா அதை ரிஜெக்ட் பண்றதுக்கு வாய்ப்பு இருக்கு. பட் இந்த பர்டிகுலர் பில்ல இட் இஸ் குட் ஸ்டெப் தட் இட் ஹாஸ் அலோவ்ட் the data fiduciary principle to ask for the data fiduciary to remove their thing. Like Facebook வந்து நீங்க வந்து சைன் அவுட் பண்ணீங்கனாலும் நீங்க வந்து அதுல வந்து பாத்தீங்கன்னா உங்களோட ஸ்டில் உங்களோட டேட்டாஸ்லாம் அப்படியே இருக்கும். ஸோ அந்த மாதிரி இல்லாம the data fiduciary is responsible to remove your data from that particular social media or anything. Okay, and users have also been given the right of grievance redressal and the right to nominate another individual in the event of the death or incapacity. So அவங்களோட டெத்துக்கு அப்புறம் கூட அவங்களோட பர்சனல் டேட்டாவை ப்ரொடெக்ட் பண்றதுக்கு they can nominate a person, and also they have the right to grievance redressal. So any problem they can reach to the data fiduciary and resolve the problem as soon as possible. And also they can, the data principals have certain duties also. They should not register a false or frivolous complaint. If that is done, they will be charged of a fine. So this is a backward step. This is a problem in this bill, which the author is saying. So இந்த மாதிரி வந்து false complaintக்கு வந்து ஏதாச்சும் fine போட்டாங்கன்னா, the data principals will fear to a case or complain against the data fiduciary. This is what the author is saying. So there is an onerous obligation which may effectively prevent a DP from rising grievances. So even if it is a genuine grievances, because there is no evidence, because evidence is very, very difficult in a data digital media, friends. So the DP may be fearful that if it is considered as a frivolous complaint, then there'll be a fine. So the DP may not complain at all. They may not raise their grievances at all. This is one concern about the data principles role, which is given in the data protection bill. Another is data breaches. Friends, I already told you the data fiduciary is responsible for informing about the data principles as well as the government if there is any data breaches. But in this bill, there are a lot of exemptions which are given. So even if there is a data breaches on certain sectors or on certain issues, the data fiduciary need not announce or need not inform the data principles about the data breaches, especially with respect to the government. This data breaches, even if it is happening, then the government may deny the information from the people. So this is very, very bad, very, very retrograde step in this particular bill, which is a cause of concern, which the bill is saying. So the bill exempts government authorities for any activities like research, archiving, or statistical purposes from releasing information, even if there is a data breaches. And also another breach. Friends, we have already discussed how this bill is affecting the RTI. There is another important step another important act which is being affected by this DPDP bill. It is the section 43A of the Information Technology Act. Actually, in the section 43A of Information Technology Actல என்ன சொல்லியிருக்காங்கன்னா, ஏதாச்சும் data breaches நடந்ததுன்னா அந்த data principal or the company or any government, anybody who is responsible for having your data, if there is a data breaches happening there, they have to compensate the data principals for that same. So they have to award damages to the affected person. But this, which is mentioned in the Information Technology Act, is overridden by the clause 44 of this DPDP bill. So there are certain exemptions which are being applied into this Information Technology Act to the compensation that is being obliged by the data fiduciaries to be given. But this bill is taking a step, unnecessary step in taking away the compensation awarding from this Information Technology Act. So this is very, very concerning, which is the author is saying. ஸோ வந்து நம்ம டேமேஜஸ் ஆர் காம்பன்சேஷன் வந்து இப்போதைக்கு கொடுக்க மாட்டாங்க. ஆனா இது வந்து சர்டைன் ஏரியாஸ்க்கு தான். ஏதாச்சும் ஒரு சர்டைன் எக்ஸம்ஷன்ல டேட்டா பிரீச்சஸ் நடந்ததுன்னா இந்த மாதிரி காம்பன்சேஷன் கொடுக்கறது ஐடி ஆக்ட்ல சொல்லியிருந்தாலும் இந்த டிபிடிபி பில்ல அதை கொடுக்கணும்னு அவசியம் இல்லை அப்படின்னு சொல்லிட்டாங்க. And then there is some qualifiers existed. That is, this particular paragraph is mentioning how this particular DPDP bill is overriding the RTA information, which I've already discussed. RTA information has to release the personal data, even if it is affecting the public interest. But this DPDP bill is saying that they need not release the personal data just because it is for the public interest, because unwarranted invasion of the privacy will happen. So the DPDP bill is preventing any release of personal data through the RTA Act. This is what the author is concerned about. And there are some role of data fiduciary, which this bill is talking about. The data fiduciary has the obligation to notify the data principal in case of any personal data breach. And other obligations imposed on the data fiduciary is that they should notify for the data which is being processed. So any data which is obtained from the data principal should be processed. So the data fiduciary should inform the DP about how the data is being used. And if it is shared with the third parties also, they have to inform. But this is not happening in this particular bill. So this is what the thing is. The manner in which they make a complaint to the DPB and withdraw concern and seek grievance redressal. So the data fiduciary should be responsible for informing the data principals about how it is being processed. So the data fiduciary is responsible for informing the data principals about how the data is being processed. And if they have a complaint, it has to be sent to the DPBB, that is Data Protection Board. And if they are withdrawing consent also, they are responsible to take away the data. And also they should address their grievances. So all these are the obligations for the data fiduciaries. There is a deviation from the 2021 bill. has removed the compensation, which we have already discussed, and data fiduciary does not mandate them to inform DPs about data being shared to the third parties. So if the data fiduciary is sharing the data to the third parties, it is not being informed by the to the data principal. So this is another problem. And there is a lack of obligation on the part of the data fiduciary to notify DP at the offset, makes the DP's right to obtain information pertaining to their personal data perfunctory. So this is very, very important, because the data fiduciary is not informing about how it is being properly processed, and if it is released to the third party also, it is not being properly announced them. So this is it is a step backward in protecting the data, which is the author is talking about. And there are certain exemptions also. Earlier in the 2021 bill, there was a mention of a word called deemed concerned. But in this particular bill, it has been modified as certain legitimate use. So in this certain legitimate use, what the thing is, the data fiduciary who is who he need not inform the data principal about how the particular data is being processed if it is used for certain legitimate use. So say for example, if the government is using your data for PDS or any schemes, because it is certain legitimate use, they need not tell you that this particular data is used for this. They need not disclose the information, but the data principals must release information for other purpose. But if it is coming under certain legitimate uses, the data fiduciary need not release release the information about the how the data is being used to the data principals. So this is a major concern that the author is talking about. And it is also failing to differentiate between certain personal data and sensitive personal data. Friends, you remember we have such a law for cyber protection. So in cyber protection, we have a law to protect critical information. So critical tech infrastructure. But in this particular bill, there is no differentiation between personal data and non-sensitive personal data. So this is a problem that the author is talking. So there is no uh, degree of protection in this particular bill. So you have to understand that always there should be a levels of protection, different levels of protection, because classification of data under different protection degrees is very important for us to responsible for the production of the different data differently. Because sometimes there need to be too much of production. இப்போ பாத்தீங்கன்னா நம்ம வைல்ட் லைஃப் ப்ரொடக்ஷன் ஆக்ட்லயே ஒவ்வொரு அனிமல்ஸையும் நம்ம வந்து ஒவ்வொரு ஷெட்யூல்ல போட்டிருப்போம். ஏன்னா ஒவ்வொரு அனிமல்ஸும் ஒவ்வொரு விதமான ப்ரொடக்ஷன் இருக்கும். அது மாதிரி ஈவன் த டேட்டா நீட்ஸ் டு பி கிளாசிஃபைட் as personal data and sensitive personal data to give a different levels of protection, which the author is talking about. And the Sri Krishna committee's draft இதுல ஒரு மாதிரி சொல்லிருக்காங்க, and in this particular 2022 bill ஒரு மாதிரி சொல்லிருக்காங்கன்னு சொல்றாங்க. What does the Sri Krishna committee says? It says that only under the security of the state we can release the information, or the data fiduciary need not be responsible for processing the information if it is for the security of the state. But in this particular bill, it is moving backward, and it has empowered the state to process data for anything, like certain legitimate use நம்ம சொன்னோம்ல, இதுக்காக government can use your data for any legitimate use. It is need not for only for the security of the state. It can use the information for certain legitimate uses, like for any schemes that is considered as certain legitimate use. So this is giving a very, very broad power for the state to use your data. So this is reducing the accountability of the usage of the data from the state, and also it is reducing your data protection, or it is reducing your privacy protection, which is the author is concerned about. And there is something called as data protection board. We already told data protection board is not having suo moto power. Only under the complaint it can take the case. And I already told you complaints cannot be coming from the people, because they don't know how data breaches will happen, how the data can be misused. They did not know, because there is a poor digital literacy that the people of India have. So data protection board is not having suo moto power is a problem. Then here in this editorial, the author is saying that data protection board's independence is also a problem because it is being appointed by the central government. All the salaries, allowances, and all may be controlled by the central government, though it is mentioned in the particular bill that it will not be modified or for the disadvantage of post appointment. So this is the important criteria to uh, to enforce the independence of any body. If you see the independent body like a CAG, Election Commission, and all, there are important provisions to ensure their independence. So there are provisions like they should not take up appointments after retirement. Their salary and all is a charged expenditure. So all these are there, and their salaries and allowances will not be modified during their tenure. Similarly, this data protection board's salary are also not modified during their tenure. But the problem is they are being appointed by the central government, which can affect their independence. They can toe the line of the government, or they can show some favoritism, and they can be it can affect the neutrality principle that the boards like data protection board should have, because there can be any complaints even against the government, because the government is also holding over personal data, and the data principals can file a case against the government itself, who is a data fiduciary. So if the data protection board is not independent, then it will affect their jurisdiction or their adjudication of cases when it's a complaint against the government. So this is a problem that the author is talking about. In overriding the concern to be obtained by the state from the data principle for purposes of providing benefits, subsidies, and licenses, the bill also does away with the purpose limitation, using the data only for the specified purposes. So the state is having a lot of power, friends. This is the important this is the important understanding that you have to have. The state is having more power to use your data for certain legitimate uses, or it can even use for non-specific purposes, like what they not mentioned. Say they would have mentioned that your data will be used for Aadhaar, but your data is being used for your another scheme. So this is not without it is done without your consent. So this is against this bill, but the state is having many exemptions, which it is using to override this particular production. So the author is saying we don't have a data production, but because the state is using your data for anything that it thinks. So this is very much a problem in this particular bill, which the author is talking about. Then the next thing is, so we have already discussed a bit about this DPDP bill, wherein we have discussed about the problem of independence of DPDP and the problem of the responsibility of the data fiduciary, especially the state having lots of power in using our data for certain legitimate uses and not only for the security of the state, as the Sri Krishna Committee recommendation. So we will now, and also we saw that there are exemptions even if announcing the data breaches also. So now we will be talking about this Rohini panel committee. Friends, we already know we are the OBC, the people under OBC category are enjoying 27% reservation. So this reservation we already know was brought by Mandal Commission, and later it was legislated, and now there is a 27% reservation. Now even there is something called as EWS category, that is economically weaker section category. They have a 10% reservation. So this is called as mandalization of politics. That is, the people are getting or demanding reservation, and this is becoming a political issue. So this we know. But the Rohini panel, what it is for is that you have to understand this Rohini panel. This Rohini panel is for subcategorization of OBC. What is it doing? It is doing a subcategorization, which means there is a OBC. This is forming 52% of a population. This 52% of population having 27% reservation. This was given by the Mandal Commission. But later it was realized that not the 52% people are enjoying this 27% reservation. It is only a few people, say 10 to some percentage, some X percentage of the people are enjoying this 27%, and the very even in the OBC category, there is a lot of people who are in the bottom layer who are not able to enjoy this. So the rich becoming richer and the poor becoming poorer is also the scenario in this case of OBC. So the OBC category reservationல எல்லாரும் இந்த OBC category reservation, அதாவது எல்லா OBC பீப்புளும் இந்த OBC category ரிசர்வேஷனை வந்து என்ஜாய் பண்ண முடியல. சில பீப்புள் மட்டும்தான் இந்த ரிசர்வேஷனை வந்து தட்டிட்டு போறாங்க. சிலர் பேர் வந்து இதை வந்து யூஸ் பண்ண முடியாம தவிக்கிறாங்க அப்படின்றது ஒரு ரியாலிட்டி வந்து புரிஞ்சதுனால there was a government which formed this Rohini panel. This Rohini panel is now thinking about subcategorization, wherein the people who are already enjoyed and has been uplifted, or they have been enjoying the upward mobility, upward social mobility in சொல்லுவாங்க. அதாவது they have become better off from the rest of the OBC people who are backward. So they have become better off from the other people who are backward among the OBC itself. So now these people will be taken as a separate category, and the people who direly needs the reservation, who are not able to gain the reservation benefit or not able to access the reservation benefits, will now be categorized as a separate people from among the OBC itself, and they will now be considered for the reservation. But what are the what how they will be getting the reservation, how this will be categorized and all, the government has to bring a legislation, or they have to do some notification to come forward. But we will understand what is the role of the Rohini panel, and what is the reality, and what is the understanding that we have to get. The reality is there are only few people who's enjoying the OBC reservation, and there are a lot of people who are not able to enjoy the reservation. So there needs to be a subcategorization. But you have to also think that Mandal commissions 27% reservation for the 52% population was considered enough. அது எப்படி மேம் 27% வந்து ரிசர்வேஷன் 52% பாப்புலேஷனுக்கு போதும்னு நினைக்கிறீங்க அப்படின்னா, சுப்ரீம் கோர்ட் ஹஸ் செட் ஆல்ரெடி in the Indra Sani case that there should be a limit, that is 50%. Total reservation should be 50%. So total reservation to be 50%. Already SC and ST is having reservation. So now OBC reservation should be within this 50%. So now 27% is the only limit that can happen with 50%. But you have to understand this EWS is 10% reservation is above this 50%, which the court will adjudicate later. Okay, court வந்து இது கரெக்டா தப்பான்றது லேட்டரா சொல்லுவாங்க. But now you have to understand this. SC ST already have certain reservation, like 18 based on their population they have a reservation. So 18% is SC, and around 8% to 9% is ST. OBC is 52%, but they have a reservation of 27%, which the Mandal Commission think it is necessary, and it's also within the limit of Indra Sani judgment. So Indra Sani judgmentல Supreme Court வந்து எல்லாரோட ரிசர்வேஷனும் 50% தான் இருக்கணும், ஏன்னா மிச்ச 50%ல எல்லாரும் ஈக்குவலா வந்து கம்பீட் பண்ணணும் அப்படின்றதுக்காக சொல்லியிருக்காங்க இந்திரா சாணி ஜட்ஜ்மெண்ட்ல. சோ வந்து இந்த ஒரு விஷயத்தினால யூ ஹாவ் டு அண்டர்ஸ்டாண்ட் திஸ் இஸ் த கேஸ். But another thing that Indra Sani judgment gave is something called as creamy layer. Creamy layer are the people within the OBC who are having a very good economy. That is their population, that is their income is more than 8 lakhs. So they will become a creamy layer population, and they will not enjoy this 27% reservation. So this becomes one subcategory which has already been excluded from the reservation. Now another subcategory will be done by the Rohini panel committee, who is again a judge. This judge, who is a retired judge, will be the head of the panel, which was constituted by the government, and now she will do the subcategorization. And another job or another task in her basket is that is she will also be analyzing the name of the OBC list, and she will be organizing the caste within this OBC. அதாவது OBC-க்குள்ள 2600 caste இருக்குன்னு சொல்றாங்க. That is 2600 caste இருக்குன்னு சொல்றாங்க. So she will be understanding what are the caste, and she will be rationalizing the name of the caste. Because friends, if you remember, there are different naming system for the caste across the state. இப்போ ஒரே கம்யூனிட்டி, இப்போ some say XYZ ன்னு ஒரு caste இருக்குன்னு வச்சுக்கோங்க. அந்த caste வந்து XYIZன்னு கூப்பிட்டிருப்பாங்க இன்னொரு ஸ்டேட்ல. So there is similar caste, but they have a different naming or they have a different spelling of their name. So like this, there are similar caste across the state, but they have a similar or different names. So there should be a rationalization or there should be proper clarification of which caste is which caste. So there are XYZ caste which is equal to XYIZ caste. So there should be a proper understanding of the caste groupings and caste names. So this Rohini panel is also doing the same, this job also, this work also. So let's see the one by one. So what is the background? We have already discussed. There is a Mandal Commission committee which gave 27% reservation. And this reservation was, 1 minute. So there is a Mandal Commission which gave 27% reservation, and this 27% reservation was countered in a Indra Sani judgment. There was a case against this reservation which was filed, and then the bench said, okay, we should give reservation for OBC, but this backwardness should not be based on the economic criteria. It should be based on the social and educational backwardness. That is what the Indra Sani judgment says. And also it has limited the reservation to totally to 50%. So this is the Indra Sani judgment. There are other things also, like how they will analyze the backlogs, how they will do the reservation and promotion and all. We will do in some other cases. But the two important thing is they have said okay for the 27% reservation, but they have limited the total reservation to be 50%, and the backwardness should not be only based on economic criteria, but it should be based on socially and educationally backward criteria. And then the Rohini Panel Committee, which was formed in 2017, it should be actually release a report in 12 weeks, but it has got 14 extensions and it took 6 years for them to come up with the report. So this is one important problems that the author is also talking about. We will see that later. The another important job of this particular Rohini panel is to rationalize this 2,600 caste, that you have to understand. And the commission was tasked with first examining how much 27% reservation should go to the OBC people, which people should get this 27% reservation. And the some people are dominating the reservation and other government benefits. Whether to take off the reservation for these dominating people and how to redistribute this reservation equitably. This is what the problem of or the task of this Rohini panel. And now the Rohini panel's report is in with the government, and the government should take the action based on proper deliberation. That is, they should consult with all the stakeholders and then only come up with the proper recommendations or any legislations or any notifications or any changes. The commission, that is Rohini Commission, was also tasked with rationalizing the central OBC list, and this data set will be for the first time show the changes. That is, already we know there was a SCCC status. Friends, you all know we did in 2011 socially, economically, we did socio-economic caste census, SCCC census. This is one census which have given the socially and educationally backward classes. But the problem is caste census have not been released. Friends, you remember this 2011 census, that is SCCC census, was done in parallel with the normal population census that is done every 10 years. But this SC census have released only the information about the socially and educationally backwardness, but it has not released the caste census. But lots of government, state government has demanded the caste census. But this Rohini panel committee coming up with this rationalizing the OBC list may be giving certain ideas about the caste census. This is what the author is talking about. Why caste census is very important, friends. One, we will be understanding which people are able to enjoy the reservation and which people are not able to enjoy the reservation, which people are becoming dominant and which people are not becoming dominant. What is dominant means they are getting political representation, they are getting employments, well, good employment they are able to get, or they are able to increase their income, or they are becoming better class people, or better standards, they're having better standards of life. So these are the things. When there is a caste census coming up, these are the things the people will understand. This is again very important for your political career of any party. So political career of any party depends on how they analyze the problems and the benefits that the people is having. So இப்ப பாத்தீங்கன்னா நான் ஒரு பார்ட்டி ஆரம்பிக்கிறேன். அந்த பர்டிகுலர் நான் இப்போ வந்து ஒரு ஒரு வில்லேஜ்ல போய் நான் வந்து ஓட்டு வாங்குறேன்னா, அந்த வில்லேஜ் பீப்புள யாரு டாமினன்ட், யாரு வல்னரபிள்னு பார்த்து, அதுக்கேத்த மாதிரி அஹ், என்னோட பேச்சு இருக்கும். என்னோட மேனிஃபெஸ்டோ இருக்கும். So caste census is similar to that. So knowing the caste is very important, friends, because this is very, very important for the political career of any parties. So this is again telling that though we don't have the caste census based on the 2011 SECC data, but using this Rohini panel, if at all released, we will be able to get access to the caste census. This is what the author is saying. And this is significant in the light of the clamor for a caste census. This is very important, friends. And further, there can be a direct effect on the electoral mathematics of political parties. So based on the caste understanding, they will be able to tune their uh, party politics. So this is very important for you to understand, friends. So friends, again, I have to recall you. Rohini panel committee, as you know, it can be a problem as well as a advantage. Friends, if you know, the advantages are we are able to subcategorize OBC, and we are able to target the reservation to the people who need it, the people who are not able to enjoy it, the people who are vulnerable and they are not able to access the reservation. So this is an advantage of this Rohini panel committee recommendation. But there was always a delay in releasing this data because there can be a lot of political problems. What is the political problems? There can be certain caste clashes saying no, we are not we are not poor, or no, we are not dominant. Similar to Manipur issue, if you recall Manipur issue, what is the problem? It is a reservation problem for the Meiteis population. So this Manipur issue is still burning. So I don't think Rohini panel committee recommendations will be published now, because again there can be a similar problems like Manipur, which can happen in any states because of the caste clashes. So this is very, very important. So I would respect the decisions of delaying this particular panel committee, but this particular author is saying it is being delayed so much, so much so that it is there is a lot of or there is a lack of transparency in releasing this particular report. This is what the author is saying. So there was a lot of extensions that was done for this Rohini panel committee. And if you understand, first it was extended. That is, the Rohini committee panel's recommendation was delayed because of the COVID pandemic, and later it was delayed because there was a lot of OBC caste which has to be rationalized. So நிறைய caste வந்து பேர் மாத்தி பேர் சேஞ்சஸ் இந்த மாதிரி நிறைய ப்ராப்ளம் இருந்ததுனால கொஞ்சம் டிலே ஆச்சுன்னு சொல்றாங்க. அதுக்கப்புறம் there was another delay because there was time taken for finalizing the annexes, and later it now is in the government's table, and now the government has to take a decisions, and they have to take some changes based on this recommendation. Even see now, if you understand, the government can release it, they need not release it. The government can take actions or need not take actions on the recommendations of the Rohini panel, because if you understand, always a panel is a recommendation and it's not a binding obligations for the government to take steps against it, but it is having a lot of political implication. That is, you have to understand. Simply releasing the Rohini panel committee recommendation itself enough for the political backlashes or political problems or political discussions, if you understand. So there are, even if you release this Rohini panel committee report itself, it is enough for any political discussions or any changes that is happening in the society. But if the government is taking any action, it will be really a positive step to target the people who direly needs the reservation. So that is very important, because only rich is becoming richer and the poor is always becoming poorer. So that is the problem. So reservation has to reach the poorest of the poor. That is what the Rohini panel was formed for. So that has to be realized, which we will do, which we will see whether it is happening or not. Okay. So next particular thing is bureaucracy as prosecutor and judge. Friends, if you understand, there is always a thing called separation of power. What is the separation of power? The judiciary should be separated from the legislature as well as the executive. Why? Because the judiciary will be adjudicating against the legislative as well as the executive to protect the citizens. If the citizen is having any grievances against the laws or against the parliament ministers or any state government or the executives like bureaucrats or anybody who can misuse their power or they can abuse their power or they can do something harassment of the citizens, so there should also always be a checks and balances, that is in the form of judiciary, who is having something called as article 13 to review any laws, or they have a article 32 to give a writ petition. So all these are there as a separation of power. But there are certain things like the bureaucrats, that is IAS officers, becoming a magistrate or judicial magistrate in the colonial times. So colonial timeல, அதாவது பிரிட்டிஷ் டைம்ல அவங்க வந்து IAS officer will be a judicial magistrate as well as a judicial of I mean he will be a district collector as well as he will be a judicial magistrate. Magistrate means they will be giving any like a court, they will be giving justice, so they will be adjudicating the cases, they will be providing their judgment. So this was taken away after the independence, because article 50, which mentions that the judiciary and the legislative or the executive should be separate. This is although it is only a DPSP, அதாவது டைரக்டிவ் பிரின்சிபல்ஸா இருந்தாலும் இதை வந்து நம்ம வந்து நிறைய இடத்துல ஃபாலோ பண்றோம். அதாவது ஜுடிஷியரியும் நம்ம எக்ஸிக்யூட்டிவ் அண்ட் லெஜிஸ்லேட்டிவும் நம்ம செப்பரேட் பண்ணிட்டோம். ஏன்னா செப்பரேஷன் ஆஃப் பவர் வந்து நம்ம வந்து பை ஸ்பிரிட் வந்து நம்ம ஃபாலோ பண்றோம். தோ தேர் இஸ் நோ லெட்டர் டு மென்ஷன் தட் செப்பரேஷன் ஆஃப் பவரை நம்ம நம்ம வந்து ஃபாலோ பண்ணணும்னு நம்ம கான்ஸ்டிடியூஷன்ல சொல்லலைனாலும் நம்ம வந்து பை ஸ்பிரிட் வி ஆர் ஃபாலோயிங். ஸோ நம்ம ஐஏஎஸ் ஆஃபீஸரை வி ஹவ் ஒன்லி கிவன் தி ரோல் ஆஃப் பீங் அன் அட்மினிஸ்ட்ரேட்டர் and they don't have a role of a judicial magistrate. So after independence, IAS officer is not a judicial magistrate anymore. They're only an administrative officer. Who is doing this judicial magistrate function? It is the Supreme Court, it's the High Court, it's the District Court, it's the Session Court. Who will do this judicial magistrate function? Only the people who have done law, who have practiced as a lawyer, who have been registered in the Bar Council of India, and then becoming a judge after the appointment by the president with the collegium. Then they will become a judicial magistrate. But now you have to understand, IAS officer is not it is not a judicial magistrate, but he is only an administrator. But what happened is recently, there are after 1970s, there are a lot of problems of separation of power. What happened? Many IAS officers are given many powers as a judge. They become a prosecutor and a judge. What is prosecutor and a judge? Why IAS officers should not do a judge function? Because they are doing the job of government, or they are implementing the policy. During the policy implementation, there can be any problems that can happen to the citizens. ஸோ சிட்டிசன்ஸ்க்கு ஏதாச்சும் பிரச்சனை நடந்ததுன்னா அதுக்கு யாருக்கு அகேன்ஸ்டா அவங்க வந்து கம்ப்ளைண்ட் பண்ணுவாங்கன்னா ஐஏஎஸ் ஆஃபீஸர் அண்ட் த கவர்மெண்ட். இப்போ ஐஏஎஸ் ஆஃபீஸரேக்கே ஜட்ஜ் மாதிரி ஆக்ட் பண்ணாங்கன்னா it will be a conflict of interest. So the citizens will not have any solution to file a case against the IAS officers or the government. And the IAS officer will have too much of power, and so he can be corrupt. So this you understood. So this you have to understand. So this you have to understand, because IAS officers should not be doing the role of the judge. That is simple. So this is against the separation of power. So we have taken the power of the judicial magistrate out of the IAS officer. But what happened? By constituting tribunals, by constituting investigation officers or prosecuting officers or prosecuting institutions like Enforcement Directorate or CBI, CVC. Okay. And then also there are certain developments which are giving the power to the IAS officer to be like a judge also. So this is a problem which the author is talking about. Let's go one by one with this particular data in this particular editorial. There was something called as John Vishwas Act. Since I already discussed about John Vishwas Act in the earlier editorial, John Vishwas Act is simply, it is a conglomeration of 42 legislation. What is this John? John means for the people. Okay, John Vishwas Act actually is decriminalizing many offenses which was once criminalized. So நிறைய ஆக்ட்ல சில கிரிமினலைசிங் அஃபென்சஸ் இருக்கும். அந்த அஃபென்சஸ் எல்லாம் டீக்ரிமினலைஸ் பண்ணி வெறும் சிவில் பெனாலிட்டி கொடுக்கிற மாதிரி மாத்துறதுக்காக ஒரு இம்பார்ட்டன்ட் பில்லை வந்து கொண்டு வந்தாங்க. ஸோ இந்த ஆக்ட் மூலமா தேர் வில் பி ரிடக்ஷன் ஆஃப் த penalty offered for any offenses, or there can be decriminalization of offenses. Say there is an example, say for example Forest Amendment Act, or there can be another act like Environment Protection Act. இதுக்கு கீழே கிரிமினல் அஃபென்சஸ்னு இதுக்கு முன்னாடி சொன்னதை வந்து இந்த ஆக்ட் மூலமா சிவில் அஃபென்சஸா மாத்திட்டாங்க. So this civil offenses is only having penalty, but criminal offenses will have imprisonment. So this is the understanding that you have to have. So there is a decriminalizing or making compoundable offenses across 42 legislation to ease the doing business, to so reduce the burden of business operations in India. So that is what this John Vishwas Act does. So நிறைய legislationல வந்து நிறைய criminalization பண்ணதுனால ஈஸ் ஆஃப் டூயிங் பிசினஸ் வந்து ஒரு மேஜர் ப்ராப்ளமா இருந்தது. அதை ரெடியூஸ் பண்றதுக்காக இந்த ஜான் விஷ்வாஸ் ஆக்ட்ல நிறைய அஃபென்சஸ் வந்து டீக்ரிமினலைஸ் பண்ணிட்டாங்க. ஸோ வாட் இஸ் த எஃபெக்ட்? There is a replacement of criminal imprisonment with penalties. So there is a civil decriminalization of the act, and also there is a monetary penalties, and so that is a good move that has to be done because we have to improve the ease of doing business. It's like Environmental Protection Act, Air Prevention and Control of Pollution Act. இதுல எல்லாம் நிறைய சேஞ்சஸ் வந்து பண்ணாங்க. But the problem is this, இதுல பெனால்டி இம்போஸ் பண்றது யாருன்னு மாத்திட்டாங்கன்னா, it is the bureaucrats, that is the IAS officers or the IFS officers, forest officers and the IFS officers who is now having the role to impose the penalty. ஸோ இதுக்கு முன்னாடி வந்து அது கிரிமினல் அஃபென்சஸா இருக்கும்போது யார்கிட்ட நீங்க போவீங்கன்னா கோர்ட்டுக்கிட்ட தான் போவீங்க, அதாவது ஜட்ஜஸ் கிட்ட போவீங்க. பட் நவ் த ஐஏஎஸ் ஆஃபீஸர் இஸ் ஹேவிங் த பவர் டு பீனலைஸ் தெம் ஃபார் எனி அஃபென்சஸ். பட் இது என்ன பிரச்சனைனா, பீனலைஸ் பண்றது தப்பு இல்லை, பட் அஃபென்சஸ் ப்ராப்பர் இது ட்ரையல் இல்லாம, அதாவது ப்ராப்பரா ஒரு கோர்ட்ல வந்து எவிடன்சஸ் ப்ரூவ் பண்ணி அதுக்கப்புறம் ஒரு ஜட்ஜ்மெண்ட் கொடுத்து அதுக்கப்புறம் அஃபென்ஸ் அதை வந்து அவங்க வந்து பெனால்டி இம்போஸ் பண்ணாம இவங்க டைரக்டா சஸ்பீஷன்னாலேயே அவங்க பெனால்டி இம்போஸ் பண்றது, இட் இஸ் அகெயின்ஸ்ட் த principle of natural justice. This, if you understand, there is something called as principle of natural justice, which means everybody is considered innocent unless until proved. So everybody is innocent until proved. So you should consider everyone innocent. You should not penalize them for offenses that you consider as an offense. You have to give a trial. You should properly prove with evidences. Then only they can be imposed with penalty or they can be imprisoned. But here, due to this act amendment, there is an overpowering of this IAS or IFS officer that they can impose the penalty even without any trial, which is usually done in the court. So this is a problem which is done in the John Vishwas Act. And another is, the larger question is whether giving the bureaucracy rather than the courts the power to not just to adjudicate a factual dispute, but also penalize or order compensation go against the constitutional scheme of separation of powers. So this is the problem which the author is talking about. And already I told you Article 50 talks about separation of power. So this particular Vishwas Act is about against the separation of power. And we have already done, say I told you friends, 1970 we have started separating the So I already told you before 1970, we started separating the judicial magisterial function from the IAS officers through Criminal Procedure Act, Executive Function Act. So using that, we separated the judicial and executive functions. This is done by the state governments like West Bengal. But the problem is now, in 1980, the bureaucracy is using different routes to capture judicial power. How they are doing? Creating judicial tribunals. If you understand, there are a lot of tribunals, friends, like NGT, National Green Tribunal, or we have a Central Administrative Tribunal, Article 323A. If you remember Article 323A and 323B, we are creating lots of tribunals. But in this tribunal, there will be 50% judicial people and 50% there will be people who are like bureaucrats, mostly bureaucrats, and the people who are from social, civil society and all. So this bureaucrats who are now getting a judicial power indirectly, which is what the author is concerned about. And second, the union government is creating a new class of statutory regulators like Competition Commission of India. This is also a judicial power. If you understand, there is something called as quasi-judicial bodies in our syllabus. So this CCI, which is a quasi-judicial body, is also manned by the bureaucrats. So they are having the judicial functions in through these bodies. And thirdly, we have the role of adjudicatory officers like ED, Enforcement Director, CBI, or many certain. So all these organization is also having the judicial functions, and this is being manned by the bureaucrats. So they are having judicial function. They're doing judicial functions, which is against the separation of power, is what the author is talking about. And the question is now whether giving penalty is a judicial function, because John Vishwas bill has taken the penalizing function to the bureaucrats. So now the penalizing function will be done by the bureaucrats. But the court in earlier cases said the judicial function should be performed only by the court. This is the pronouncement of the Supreme Court. But whether penalizing function is a judicial function or not, it is for the Supreme Court to tell. So whether this John Vishwas Act is constitutional or not depends on whether the John Vishwas Act can give the power to the IAS officers to provide penalties to the offenders. So the Supreme Court now have to say whether John Vishwas Act is a constitutional or not, based on whether the judicial function, whether penalizing itself is a judicial function or not. அதாவது penalizing வந்து judicial functionா இருந்தா கோர்ட் என்ன சொல்ல போகுது, அது வந்து ஐஏஎஸ் ஆஃபீஸர் பண்ண முடியாது, அது வந்து கோர்ட் தான் பண்ண முடியும் அப்படின்னு சொல்லிடும். இதே ஜுடிஷியல் பெனலைஸ் பண்றது வந்து ஜுடிஷியல் ஃபங்க்ஷன் இல்லைன்னா அது ஐஏஎஸ் ஆஃபீஸர் பண்ணலாம்னு சொல்லிட்டு கோர்ட் சொல்லிடும். ஸோ வெதர் திஸ் penalizing function is a judicial function or not, it is the Supreme Court which has to decide. So let's wait for the Supreme Court to uh, pronounce about this John Vishwas Act. So application of the law to the facts and determination of the punishment or compensation is an essential judicial function, is what the author is arguing. So author வந்து என்ன சொல்றாருன்னா, இந்த பர்டிகுலர் ஜான் விஸ்வாஸ் ஆக்ட்ல பீனலைஸ் பண்றது, காம்பன்சேஷன் சொல்றது எல்லாமே ஜுடிஷியல் ஃபங்க்ஷன் தான். அதனால சுப்ரீம் கோர்ட் தான் அதை பாத்துக்கணும், கோர்ட் தான் அதை பாத்துக்கணும், அது ஐஏஎஸ் ஆஃபீஸர் கிட்ட போக கூடாது அப்படின்னு இந்த ஆத்தர் சொல்றாரு. But it is the government which has to prove, or the Supreme Court has to say this. And it has to guarantee the citizen a fair trial. So trial இல்லாம வெறும் IAS officer இந்த மாதிரி penalize பண்றது வந்து it is against the principle of natural justice. It is against the essence of rule of law, is what the author is saying. And there is a backsliding on the separation of power. So remember friends, the IAS officer getting the judicial function or judicial power is against the rule of law, the separation of power, as well as what I said, it is against the natural justice because they are not getting the fair trial. So this is what the author is telling about the problems in this John Vishwas Act. So then the learning from the CHIPS Act of the US. Friends, remember we already talked about many things about semiconductors, how semiconductor industry can be can be established in India. So semiconductor industry can be established from the China's model, which we discussed earlier. China's model in which they used the companies which has been fell sick. So sick companies. அதாவது சிங்க் கம்பெனிஸ் தான் அந்த கம்பெனி ரன் பண்ண முடியாம போன கம்பெனியை யூஸ் பண்ணியே அந்த கம்பெனியை ரீஇன்வெஸ்ட் பண்ணி அந்த கம்பெனியை ரீகான்ஃபிகர் பண்ணி அந்த கம்பெனியை வந்து ரெஜுவனேட் பண்ணி அந்த கம்பெனியை ரீஸ்ட்ரக்சர் பண்ணி அதுக்கு உயிர் கொடுத்து வி ஆர் ப்ரொவைடிங் இட்ஸ் லைஃப் அண்ட் தென் வி ஆர் ஸ்டார்டிங் திஸ் கம்பெனி யூசிங் த சைனாஸ் மாடல். ஸோ இதை வந்து ஒரு ஆத்தர் சொன்னாரு, ஒரு எடிட்டோரியலை நம்ம இதை பார்த்தோம். பட் இந்த எடிட்டோரியல் என்ன சொல்றாங்கன்னா, வாட் வி கேன் லேர்ன் ஃப்ரம் சம்திங் கால்ட் அஸ் சிப்ஸ் ஆக்ட். சிப்ஸ் ஆக்ட்னு சொல்லிட்டு யூஎஸ்ல ஒரு ஆக்ட் இருக்கு. இந்த ஆக்ட்ல what they are doing, they are providing incentives. They are doing some departmental collaboration. They are doing some incubation using certain institution. So சில IITs வந்து incubate பண்ணும் சில startups. அது மாதிரி incubation is provided by certain so incubation can be provided by certain institutions or certain universities. So that can be done. And the author is also talking about they have to also create a market to buy the semiconductors. So all these are done by the CHIPS Act, especially incentives and investment are provided by this. So this is very important. So let's see what are the learnings from this CHIPS Act of the US. United States started this act. This is called as Creating Helpful Incentives to Produce Semiconductors and Science Act. This is an act which is providing investment of about $52.7 billion to boost the American competitiveness, innovation, and national security. What are the lessons from the act to improve our semiconductor strategy? The act involves cooperation and coordination between several arms of the government. So there is a need for interdepartmental coordination, interministerial coordination, and there is a 4 separate funds which are provided. So there is a we should segregate and also we should target many ministries wherein there can be a possibility of semiconductor manufacturing and also there can be a possibility of semiconductor usage. So all the ministries have to be given the funds and there should be interministerial cooperation. That is the lesson from the act, first lesson from the act. But India la enna nadakuduna, Indian's case, there is only the Meitei government, Meitei ministry which is looking after the semiconductor, and there is a secluded mission that is called as Indian Semiconductor Mission. This is a separate mission. This is an independent division. So this is a very it is not connected with any other department, but there is always a cross ministerial functioning of the semiconductors, because semiconductors நீங்க பாத்தீங்கன்னா semiconductors require all the departments to coordinate, because semiconductors need mining department, commercial department, external affairs department, home ministry department, home ministry, defense ministry, industrial ministry. So all these ministries are playing a role in the semiconductor to be successful as a manufacturing. So to manufacture a semiconductor, we need interministerial cooperation. And it is not only Meitei which should look at. It should be collaborating with all the ministries. And also there should be a interministerial coordination in the mission itself. This is what the author is telling. This is what the author is telling. So we have to have a cooperation and also we have to provide funds for all the ministries that are responsible for this semiconductor manufacturing. So companies seeking fund under the CHIPS Act has to require to submit workforce development plans. And also there is a technology center which is collaborating with industry and educational institutions. So there should be proper incubation and there should be proper facilitation for manufacturing using semiconductors. And there should be a proper development plan also. So there should be a plan, there should be a facilitation, there should be incubation, there should be funding, So all this should be taken care. Only then the semiconductor industry will be successful, is what the author is saying. There should be competent semiconductor engineering workforce. So there should be a workforce also. But they have already done a program called Chips to Startup program. This has provided training for many institutions, many workforce. Okay, but the problem is there are many private training centers which are there. So these private training centers should be recognized, and the people who are getting trained in this training center should be properly certified. So this is the problem that we should meet. So private training centers should be properly recognized, and they should be proper quality provided here. And the persons who are getting the training from the private training center should be properly certified. And there should be a connection between the private training centers and certain established institutions. So that is where it must be done. And hence, it is important that CHIPS to start a program to focus on certifying the good programs of universities or private training institutes. And the CHIPS program office, that is CPO of the US. USல வந்து the CPOன்னு ஒரு ஆஃபீஸ் இருக்கு. அந்த ஆஃபீஸ் மூலமா என்ன பண்றாங்கன்னா, they are providing access to the financial viability of the project. Friends, if you understand, whenever we are starting a manufacturing industry, there can be a lot of challenges, like whether the program is viable, or the finance is viable, or the program is feasible, or the project is feasible, is all that we should require to see. So this needs financial intelligence, or we need financial skills to understand whether the project is viable or the project is feasible. So there should be a proper officer who should provide guidelines to understand whether the project is viable or not. So all these are done in this CHIPS Act, which India can learn from. And from government also need to put regular monthly progress report about whether the semiconductor manufacturing industry is working or not. So all these should be done so that we have a continuous running of the semiconductor manufacturing industries. And also we have to help manage expectations, and have to reassure the people also, because investments can happen only when there is a reassurance and there is a proper risk testing. There should be a proper viability of the project. Only then the investments will come. Otherwise, investments will stop. So there should be proper financial management of this particular risk management of this particular manufacturing industry. And there is a Department of Commerce which is providing $11 billion. Friends, another thing is, what is the product which should come from the semiconductor industry? So semiconductor industry வந்து நல்ல ஃபண்டிங் இருக்கணும், நல்ல ஒர்க் ஃபோர்ஸ் இருக்கணும், நல்ல viability செக் பண்ணி ஸ்டார்ட் பண்ணணும்லாம் பேசிட்டோம். So how it should provide, what is the product it should provide? The CHIPS Act, அதாவது USல what they have done is, in the they are packaging all the important semiconductor thing. So the packaging is a leverage point to excel in semiconductor, is what the understanding from the CHIPS Act. So packaging is very important in the semiconductor industry. So we also should focus on this packaging. We should do advanced packaging techniques that combine multiple semiconductors in a multi-dimensional arrangement, all in one package. So this is the product which we have to sell. Only then there will be demand from the market, because there is a lot of semiconductors which are provided. We already saw in the previous editorial that logical chips is more demanded, more than the memory chips and the basic analog chips. So memory chips analog chips market ஓட demand வந்து கம்மியா தான் இருக்கு. லாஜிக்கல் சிப்போட டிமாண்ட் தான் அதிகமா இருக்குன்னு நம்ம பார்த்தோம். அதே மாதிரி நிறைய செமிகண்டக்டரை பேக்கேஜ் பண்ணி கொடுத்தா மட்டும்தான் டிமாண்ட் இருக்குன்னு சொல்லிட்டு இந்த ஆத்தர் சொல்றாரு. So this is also the learning from the CHIPS Act. So from the CHIPS Act, this is also learning that you have to do. And in sum, the CHIPS and the Science Act is a useful template for industrial policy in semiconductors, and the administrative capacity that the US has marshaled must be emulated in India also. So US ஓட CHIPS Act வந்து நம்ம வந்து பாலிசிக்கு, அட்மினிஸ்ட்ரேஷனுக்கு, அதாவது நம்ம இன்ஸ்டிடியூஷன் கிரியேட் பண்றோம்ல, இதை ஓவர்சீ பண்றதுக்கு, இதை ரெகுலேட் பண்றதுக்கு, எல்லாத்துக்கும் நம்ம வந்து லேர்னிங்ஸ் ஃப்ரம் CHIPS Act வந்து நம்ம பண்ணலாம் அப்படின்னு சொல்லிட்டு இந்த ஆத்தர் சொல்றாரு. Nothing matters in the industrial policy than effective implementation. So நம்ம policy மட்டும் பண்றது பத்தாது, we should also implement it. So we have to learn from the CHIPS Act the way we have to do interministerial coordination, the investments, the products, as well as the important things like how we are doing incubation and all. So, and also we have to frame a proper policy based on this learning, and we have to implement it also. This is what the author is talking about. And the last but important editorial is how we are going about this Project Tiger. Friends, if you remember, we have increased the tiger population. In the earlier editorials, there was a concern raised, about the human wildlife conflict, because there is an increasing wildlife population like tigers. If there is an increase in tiger population, there can be a possibility of human wildlife conflict. Why? Because the tiger is basically a territorial animal. It needs proper spacing for its survival. So it's a territorial animal. It needs a space for its survival. So when there is an increase in population of the tiger, it will increase its space. So there is a need to increase the space. But our national park or sanctuaries are fixed in the borders. So they will start going into the. So having increase in population of the tigers, we have a challenge of giving space for the tigers, and they are now in coming into the human areas. Like mostly it will be the tribal areas or the forest, the farm, villages, because there is a probability of prey. Because they have the livestock population. So cattle can be an important prey. So that's very important, because also we should mention that prey predator population should be balanced enough, that the the space is enough for the tigers. ஸோ ஒரு டைகருக்கு வந்து அதோட ப்ரே பாப்புலேஷன் எனஃபா இருந்தா மட்டும்தான் அது வந்து அந்த ஸ்பேஸ்க்குள்ள இருக்கும். இல்லைன்னா இட் வில் கம் அவுட் அண்ட் சர்ச் ஃபார் ப்ரே. தென் இட் வில் கம் இன் in conflict with the man. So there is a problem that this can happen. So this is the problem which the author is talking about. What is the background? The population or the recent reports is the important things that we have to understand. So tigers are endangered, as you all know. We have the largest population of the tiger in the world, and we have a population now increased to 3,682. Madhya Pradesh is having the largest one, and there is a learning from the Madhya Pradesh. Madhya Pradesh has done a very good, tremendous work, because Madhya Pradesh, what it has done is, has taken the tigers, whenever there is increase in population, they have taken the tigers to the areas or the national parks in which there are little number of tigers. So they have transported the tigers to the areas where there can be there is always a or sorry, I had a cough. Okay, so Madhya Pradesh has done a very, very good work, because whenever there is an increase in population tiger in a national park, they have released the tiger into some other national parks, so that there is always a balance between the prey and the predator population. So a well ecological balance is very important, because this ecological balance is very important, because otherwise either the tiger will go into this the human habitat area, or there can be clashes between the tigers, and the tigers population will reduce, or there can be clashes between the other carnivores, and there can be reduction in the population of the tigers. So there can be a problem anyways. So ecological balance should be maintained. But another thing is very important, which the author is talking here, is there should be always compatibility in the habitats. What is compatibility in the habitats? That is, this national park and the another national park in which the tiger is to be released should be always similar in similar in all the ecological aspects. So this is what the author is talking about, which is a good way in which Madhya Pradesh has done to increase the population of the tiger, because 785 tigers they have to accommodate within Madhya Pradesh itself. So they have released the tigers, or they have balanced the tigers in the national parks they are having. So this is very important learnings that we have from Madhya Pradesh. But there is also a indirect criticism in this particular in this editorial, which I was able to interpret. I think many of you could have interpreted also, because there is a lot of problem in the cheetah's reintroduction program. Cheetah's reintroduction program. What is the realization is there are a lot of cheetahs which have been which has died because of the incompatibility in the habitats. Because friends, you have to remember there are a lot of things in the food chain or in the food web which we may not realize when we are tampering with the nature. ஸோ நேச்சரை நம்ம வந்து மாற்றும் போது நிறைய விஷயம் வந்து நடக்கலாம். இப்போ வந்து நான் வந்து டைகரை வந்து நான் வந்து சாரி, நீங்க வந்து சீட்டாஸை வந்து நீங்க யூ ஆர் இன்ட்ரடியூசிங் ஃப்ரம் த ஆஃப்ரிக்கா. ஆஃப்ரிக்கன் சீட்டாஸ் இஸ் டோட்டலி டிஃப்ரெண்ட் ஜீன் ஆர் ஜெனட், தே ஆர் டோட்டலி டிஃப்ரெண்ட் genotype than the Asian cheetahs, and the climate and the habitat is totally different from the Africa, and there can be any problems here. In this case of cheetah's death, one of the death reason is that it is it is important you understand that one of the death reason is that cheetah is facing the problem of the organ failures. This is one reason. So organ failures can happen because they are unable to adapt. And another is there are some bacteria like maggots, in which the cheetahs, the African cheetahs were not resilient, or they are not able to find immunity against these bacteria or viruses which are there in the current habitat or Kuno National Park. So these are the different things which we cannot predict, because there can be a lot of chain reactions which can happen. So it is always important that we understand the principle of ecology and then go by that. So this is one important learnings that we have to do based on the tiger population increase, and we have to do many steps for improving tigers also, and also we have to do or take certain learnings from this tiger project also. So MP is very important model that we have to learn from, and there should be a principles of ecology, and the concern is that there was Forest Conservation Act, which is doing a lot of changes. Friends, Forest Conservation Act amendment has been already discussed. There are a lot of changes that has been done. There can be exemptions for introducing any roads or any projects in the 100 kilometers in the national borders. So all these are leading to fragmentations of forest. So fragmentation of forest will result in lot of problems for the tiger population. And there will be lots of human wildlife conflict also which will happen. So there should be a lot of things which we do have to do in order to protect our environment as well as protect our tiger population. And also from the learning from Madhya Pradesh, we also should understand it is only not the tiger which is being very important for us. It is also the prey population which should be protected and which should be enhanced. Their population should increase for the tiger population to increase. So the prey population is very important, and the whole landscape is very important. We should not fragment the landscape. We should not cut the forest. We should properly provide or protect the corridors like elephant corridors or tiger corridors, and we have to avoid creating fenced. Fenced here means the fragmentation problem that the author is discussing about because of the amendment to the Forest Conservation Act. Friends, if you remember, try searching for edging effect or edge effect. What is edge effect? Simply means edge effect. If you are fragmenting a forest, if this is a forest and I am cutting the forest in between, there will be two different forests which is created, and there will be a lot of problems because this will be created as a transitional zone which will create a different ecosystem. So there is a breakdown or fragmentation in the ecosystem of the forest, which will result in the edge effect, because edge effect will release different habitats that like there can be some alien species which are coming. This will affect the indigenous species there. So there can be a lot of changes in the ecosystem which will affect the tiger population and the normal prey population there. So there should not be any fragmentation of the forest. The forest should be conserved in their pristine form, so that we are able to protect the prey population as well as the tiger population in turn. So now we have to focus on the landscape. We should not fragment the forest, and we should protect the prey population as well as with the tiger, which is the top carnivores or which is the keystone species or the flagship species. So that is the important takeaways that we have to learn from this particular editorials. And it is time that prey management policy is taken care, and support from people should be there also, and move away from the approach of focusing on carnivore, and we should also protect the habitat necessary for the carnivores to survive. So these are the important editorials, friends. I have excluded all those editorials which are political, and all those editorial which are only discussing the only criticizing the government in a negative manner. Though there is a Manipur issue which we have already discussed, so I'm just excluding that. And the recent Haryana communal violence, we have to wait for some important outcomes, because now most of the editorials are criticizing the government. But the important thing is there are certain lacunas in the intelligence, because only there is always a hint about communal violence even before it is happening. So proper intelligence, if you have considered the intelligence, then this communal violence would have been stopped, because there is there is a lot of preparation in starting this communal violence. Because friends, in the communal violence-க்கு நிறைய ப்ரிப்பரேஷன் நடந்திருக்குன்னு சொல்றாங்க. ஸோ அதனால ப்ராப்பர் இன்டெலிஜென்ஸ் வச்சு நம்ம இந்த கம்யூனல் வயலன்ஸை ஸ்டாப் பண்ணியிருக்கலாம் அப்படின்னு இந்த ஆத்தர்ஸ் சொல்றாங்க. ஸோ லெட்ஸ் சி what is the development, what is the court or what is the government is coming up with. And other things we have already discussed in a lot of editorials, and the further important editorials we will discuss in the future if it is very, very useful for the UPSC preparation. So thank you so much, friends. Wish you all good luck. Your mains are coming very soon. I wish you all the very best. Keep learning and enjoy learning. Thank you.